Welcome to Learn About Law. My name is Kevin O'Flaherty from O'Flaherty Law, and today we're going to talk about spousal rights to inherit qualified retirement plans in Illinois. First, let's talk about what a qualified retirement plan is. It's a retirement plan that receives preferential tax treatment. So the most common examples are 401ks, IRAs, and pensions. And we'll talk about a spouse's right to inherit each of those because they're a little bit different for each one. So for a 401k, the surviving spouse generally will have the right to inherit all money in the 401k account. The exception is when the surviving spouse signs a waiver allowing the account owner to name a different beneficiary. So the spouse doesn't have to be named as a beneficiary on the 401k account in order to inherit everything in the account. And unless this waiver is signed, the deceased spouse naming someone else as a beneficiary won't prevent the surviving spouse from inheriting the account. However, naming the surviving spouse as the beneficiary on the account will speed up the payout process. So it's best practice to make sure that your spouse is listed as the beneficiary on your 401k accounts, and if you have children, list them as successor beneficiaries. So as far as IRAs are concerned, these differ from 401k accounts in that they are not automatically inherited by the surviving spouse in Illinois. The account owner is free to name a different beneficiary, and if he or she does so, then the surviving spouse will not necessarily inherit the IRA account. Now, this is different in states outside of Illinois. Community property states hold that IRA accounts are equally owned between both spouses. So Illinois is not a community property state. So in Illinois, you can name a different beneficiary from the spouse, and the spouse isn't necessarily automatically entitled to inherit the account. So if you're moving from Illinois to somewhere like Arizona, be careful, make sure you know what the local state law is in order to make sure that the account is distributed the way you want when you pass away. Pension plans. The surviving spouse will receive an annuity from the plan, and the annuity will be a greater percentage of the amount that the deceased spouse would have received, depending on whether the deceased spouse passed away after retirement or prior to retirement. So if they passed away prior to retirement, it's going to be a smaller percentage. If they passed away after retirement, it'll generally be 50% of what the deceased spouse would have received under the plan. So if you have any questions, you can leave them in the comment section below this post at learn-about-law.com or below the video on our YouTube station. If you need some help, please give us a call at 630-324-6666. That's 630-324-6666. We offer free consultations in many areas of law, and we have several geographic locations for your convenience. If you found this helpful, we'd love it if you'd subscribe to us on YouTube, SoundCloud, Apple Podcasts, or wherever you listen to your podcasts or watch your videos. Thank you so much for watching and listening.
Thanks so much for watching our video. If you have any questions, feel free to comment below. Click the subscribe button for new videos every week, and download and review us on iTunes. Visit learn-about-law.com for other legal-related articles and videos. Visit our business podcast and video blog, seizeyourbusiness.com, and visit Making Real Estate Fun for real estate videos and podcasts. Call us at 630-324-6666 for a free consultation.